Major breaking news out of New York City today. The Second Circuit Court of Appeals heard argument in the case of Zherka versus Merrick Garland dealing with the application of a major federal gun control statute, 18 U.S.C. 922 G1, dealing with individuals that have previously been convicted of crimes and whether or not they can be denied the right to keep and bear arms for the rest of their lives because they were previously so convicted. Stay tuned. Let's talk about what happened this morning in New York City. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new book, Disarmed: What the Ukraine War Teaches Americans About the Right to Keep and Bear Arms, where I basically take lessons from the Ukrainian experience with their refusal to adopt a Second Amendment 10 years ago and the consequences they paid for it, and how we as Americans need to learn the lessons of the mistakes of the Ukrainian people and their government so we don't make those same mistakes and disarm ourselves, which I'm sure we won't because we're not that foolish. Okay, folks, breaking news. This morning in New York City, major oral argument today in the case of Zherka versus Merrick Garland. The question presented was under the Supreme Court's precedents of Heller and Nysurpa versus Bruin. Can Mr. Zherka be disarmed for life under the federal gun control statute of 18 U.S.C. 922 G1 because he was convicted many years ago for a felony touching on filing a false tax return? No suggestion of violence in Mr. Zherka's past. This is a felony tax issue, similar to, but different, of course, than Martha Stewart. Martha Stewart was convicted of lying to the FBI, I believe. No evidence of violence there. And the question is really the Martha Stewart question of why should Martha Stewart be denied the right to keep and bear arms for an administrative crime that technically constituted a penalty under the federal definition of a felony. So that was what happened. Key facts here, just so you're aware, in December 2015, Mr. Zherka pled guilty in the Southern District of New York in the United States District Court there for a false statement relating to filing certain bank statements and federal income tax returns being false. He was sentenced to prison. He served out his term. And basically, as a result of that, under federal statutory law, even though everything he's done is nonviolent, he's denied the right to keep and bear arms under the statute. So he brought this Second Amendment challenge saying that this is unconstitutional, that he is not dangerous in any respect. There's never been any proof or evidence that he's dangerous, and the mere fact that he was convicted of a crime that the federal government defines as a felony should not be a basis for him to lose his fundamental individual right to keep and bear arms for the rest of his life. The defendant here is obviously Merrick Garland, the Department of Justice. That's who's defending this case. This is a civil case. Now, there's bad news and good news. Sometimes I've tried to explain to you that bad news in the short run ultimately can give rise to good news. For example, when the nutty gun control states do stupid things with gun control laws, in the short run, that's bad. It's bad that like DC banned guns, specifically handguns, but it gave rise to the Heller decision. It's bad that Chicago banned handguns back in the day, but it gave rise to the McDonald decision. It's bad in the short run that Massachusetts banned stun guns, but that gave rise to the Caetano case in 2016. And of course, it's bad that New York State adopted the May issue permitting regime that said you had to go to the state and ask mother, may I carry a gun outside the home for self-defense? And they got to decide whether or not you were good enough. It didn't matter if you're just an American citizen. That was not considered sufficient. But again, these kinds of crazy gun control laws often give rise to good outcomes in court and great precedents for the Second Amendment, whether it be Heller, Caetano, McDonald, or Bruin most recently. So just keep that in mind. Now, with that said, this 3-judge panel, in my opinion, is a loser when it comes to the Second Amendment. We're going to lose this case probably 3-0. The 3 judges are John Newman, who was appointed to the federal bench by Jimmy Carter, Gerald Lynch, who was appointed to the federal bench by Barack Obama, and Myrna Perez, who was appointed to the federal bench by Joe Biden. If you listen to the oral argument here, I'll put a link to it down below. Pretty clear that this 3-judge panel was really working hard to defend the view of the Department of Justice. They were essentially attacking, in effect, the rationale of the Supreme Court's decision in Nysurpa versus Bruin. It's clear that they don't like guns. It's clear they don't like the Second Amendment. And it's clear they're looking for a way to circumvent this. So that's the bad news. We're going to lose this particular case in the Second Circuit Court of Appeals. I feel highly confident of that unfortunate outcome. So that's the bad news. And I'll tell you why, and then I'm going to tell you why it's good news in the long run as I see it. First of all, let me tell you, in addition to the fact that the panel is just generally bad, if you listen to their arguments, one of the things they were focused on is trying to figure out what dangerousness could mean, because the first argument the Department of Justice says that the right of the people to keep and bear arms excludes from the definition of the people those that have been convicted of crimes, because they said the only people that are entitled to keep and bear arms are those that the government can trust. These are people that behave, they've never broken a law, anything like this. Now, of course, that rationale is, just as a reminder, the way the Zherka versus Bruen works is you start with the text of the Second Amendment as interpreted by the Supreme Court. The government here, Merrick Garland, was arguing that the people, as in the right of the people to keep and bear arms, does not include anyone that violates the law. But that is not true, because the Supreme Court has repeatedly says that the people, when it comes to the Bill of Rights, including the Second Amendment, includes all Americans. All Americans are part of the right of the people to keep and bear arms. So at a textual level, it is clear that Mr. Zherka, as an American citizen, is protected textually by the text of the right of the people to keep and bear arms. Now, as a consequence of that, the burden shifts to the government. As you know, once the text is implicated by gun control law, the Mark Smith rule that I made up, but you can take, is when in doubt, throw it out. When in doubt, throw it out. Meaning that once the text applies to a modern-day gun control law, the presumption is that law, that gun control law, is unconstitutional and should be tossed out into the trash heap of history. That is the presumption. The only way the government can overcome that presumption is by showing long-standing historical traditions of gun regulations, not, again, general history, not the views of some historians spouting off about some theoretical concept of the meaning of history. No, it's specific. The Supreme Court said twice in Zherka versus Bruen that the government must come forth with historical analogs of actual regulations, which means laws that are enforceable. You can go to jail, you can be put in sued, whatever it is, some sort of actual law on the books from the time of the founding through now. And again, the example I always give is you could not use a gun to commit murder at the time of the founding. You cannot use a gun to commit murder today. That was always the case, and that is the kind of example that of a long-standing historical gun regulation that would be viewed as acceptable and consistent with the right of the people to keep and bear arms, because historically, no one was allowed to use a firearm or an arm to commit rape, robbery, or murder, and that is what we're looking for here. So unless the government can come forth with evidence on that level of terms of compelling nature, persuasiveness, starting from the time of the founding through today, unless they can find examples of that, they lose. When in doubt, toss the law out. It is the Mark Smith rule, but you can use it and take that line, feel free. Okay, now, so in this case, with Mr. Zherka as the plaintiff suing Merrick Garland, the question presented is, of course, at the textual level. Clearly, he's part of the people because he's an American citizen. So now the burden shifts to the government, in this case, the Department of Justice, to try to justify the historical ban on people convicted of felonies losing their right to keep and bear arms forever. Now, the pro-gun side basically says that the historical rule for denying someone the right to keep and bear arms is, are they dangerous? Specifically, if you're an American citizen at the time of the founding, but then you decide you're going to fight with the Tories, meaning with the British government, that would be an example where you become dangerous and they can take away your right to keep and bear arms. Things of this nature, if you've been convicted of a violent crime and they put you in prison, they can take away your guns there. So these are examples where people are dangerous to society at that moment, and it's clear they're dangerous, violently dangerous, and that can be a basis for taking away someone's right to keep and bear arms while they're dangerous. Now, one of the big things here is the judges were trying to get around that. They seem very sympathetic to the view that if you cannot be trusted as an American citizen, then they can take away the rights. Now, that is a very dangerous standard, because the other related thing that the judges were seen to be intent on is that who gets to decide who is dangerous? Is it the courts or is it the legislature? We know the right answer should not be the legislature, because if you allow the legislature to define rights without going through the Constitution or the courts, we're in big trouble, because Congress could in theory define those of us who do not recycle, who jaywalk, who drive 5 miles per hour over the speed limit on a highway, or engage in all sorts of other activities that are minor in nature, minor trespasses in some way, there's nothing would prevent Congress from saying that those are a basis for not respecting the rule of law, and thus we lose our right to keep and bear arms. That cannot be the meaning of the Second Amendment, but that seems to be where these judges were going toward. Basically, if you're not willing to respect these basic kind of rules of society, no matter how stupid they may be or silly they may be, like again, recycling, then if Congress so deems it, they can take away your right to keep and bear arms. But that cannot possibly be the rule any more than you could take away your right to free speech or your right to practice a religion because you don't comply with the law. How would it be any different? Again, the touchstone is dangerousness, but the Department of Justice in the three-judge panel was basically trying to say that the touchstone is more virtuousness. If you're not virtuous, meaning you don't respect the laws of the society, if you don't show virtue, and Congress doesn't think you're virtuous, they can take away your right to keep and bear arms forever if they so choose. That seems to be where the tension is. Now, the reason why this case of Zherka, even if we lose, is potentially good news is keep in mind that right now, as we sit here, okay, you know from this channel, because we've covered this before, in the Third Circuit Court of Appeals out of Pennsylvania, New Jersey, there's a pending case called Bryan Range versus Merrick Garland that presents the same legal question involving the Second Amendment as this case here in the Second Circuit Court of Appeals of Zherka versus Merrick Garland. Now, while I believe that the Second Circuit Court of Appeals with a three-judge panel is going to rule against Mr. Zherka in favor of their government on the Second Amendment claim, I think that the Third Circuit Court of Appeals is going to come out the opposite direction. So this is why it's actually, strangely enough, good news in the long run if this three-judge panel does the wrong thing and rules against Mr. Zherka and shrinks the scope of the Second Amendment, because that is almost certainly in my best prediction, and my predictions are usually pretty good. My prediction is that the Second Circuit Court of Appeal here in the Zherka case is going to say that those that have been convicted of crimes in the past lose their right to keep and bear arms forever. That's okay. And then in the Range case in the Third Circuit Court of Appeals in Pennsylvania and New Jersey, they're going to reach the opposite conclusion. And as a result of these conflicting views, you have what is known as a clear circuit split, where you have different circuits in the United States, the Second Circuit here and the Third Circuit here, reaching different conclusions on the same federal question involving the interpretation of, in this case, the Second Amendment. And in those situations, it is usually the case that the United States Supreme Court will resolve the circuit split by taking the case. In this case, they would, be looking to take either the Range case or this case, take this case and tell the federal courts down below whether or not the Third Circuit view that the Second Amendment cannot be thrown out unless there's a proof of dangerousness, or whether the Second Circuit would be right, assuming they write the opinion the way I think they're going to write the opinion, which is just virtuousness is what counts. If you're not virtuous, then they can take away your right to keep and bear arms. So that, I think, is going to create a circuit split and that the Supreme Court can, in turn, use as an excuse to pull up in front of them, and they can issue a major Second Amendment ruling on this question. And that's why I think that even though I think Mr. Zherka is going to lose in the Second Circuit Court of Appeals, he may ultimately win for all of us in the Second Amendment community. Only time will tell, but I think that's where it's going to go. But the bottom line is, big argument today in New York City involving the Second Amendment. I'll put a link to it down below. You may want to check it out. Interesting arguments, very similar to the kinds of things we saw in the Range case in the Third Circuit argued about 3 months ago. Haven't heard back on that. I'm guessing we'll hear a decision on that case in the next 60 days or so out of the Third Circuit. And as to when we hear a decision on this Mr. Zherka case, I suspect this will be the next 90 days or so before we hear an opinion or get an opinion from the Second Circuit on the Zherka case. Okay, folks, hope you learned a little bit something here today. Don't forget to check out my book, Disarmed, What the Ukraine War Can Teach Americans About the Right to Keep and Bear Arms. It's all about the Second Amendment and our founding fathers and, how Ukraine screwed up, unlike Americans, and don't make the mistake of the Ukrainians. Okay, folks, if you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.